Hello. Okay, good afternoon, ladies and gentlemen. I'm Eeling Chiu, the Secretary General of Taiwan Association for Human Rights. And thank you for everyone to participate in the panel. And also this is my honor to moderate the panel, Regional Transparency Report and Online Rights Protection Measures. Today we have a lot of great speakers from different countries, and we love to hear from them about their findings and difficulties on the topic. From 2010, Google announced the first transparency report in the world, and after Edward Snowden's leak event, so far there are more than 60 corporations and organizations released their transparency report. Among these reports, some will especially focus on the government's statistics and request the government to expose the related information and seek a more open and transparent government. Different from the corporate transparency report, these reports are usually produced by the civil societies. Today we have the Hong Kong Transparency Report, which is organized by the Media Research Center in Hong Kong University. Benjamin Zhou is in charge of the project. And Hong Kong released the first government transparency report in 2013, and their report has become a very important reference for other countries. And also, Korean Internet Transparency Report is managed by a clinical legal education center, and Mrs. Ji Won-sung from Korean University Law School, with the assistance of the OpenNet, is in charge on the report, and they finished the second report last year. And Taiwan Transparency Report is made by Taiwan Association for Human Rights, and Mr. Ming-Shen Ho is in charge of the project. And the project started from 2014 and released the report last year. And if you are interested, the report, today we have some printed version here, and welcome to have one. And China, Mr. Clement Chen, who is the postdoctoral fellow in the Faculty of Law in Hong Kong University, and he's the expert in the transparency issues on the PRC government. Although there are no transparency report in China, but Clement will introduce us about the surveillance and censorship in China. So now, maybe we just start from the first speaker from Hong Kong, and each of you will have 10 minutes to present. And after that, we will have 20 minutes for discussion.
Yes. Next. Good afternoon, ladies and gentlemen. I'm Benjamin Zhou from Hong Kong Transparency Report. Welcome to join us. I'm going to introduce the Hong Kong Transparency Report. We published the first report in 2014, and we are going to publish the second report in 2016. Let me introduce what is Hong Kong Transparency. What was Hong Kong Transparency Report? Hong Kong Transparency Report is a transparency report basically focused on how the Hong Kong government obtained the user data information and the content, and to ask the internet service providers to remove some content online, like most of the corporate transparency reports, like Google, Facebook, Twitter. But we focus on the government information. So as I said, we were established in 2013 and published the first report in 2014, and we're going to publish the next report. So today here, I'm introducing our 2014 report. It's just the executive summary. So first, the resources. We obtained information from two resources. First, it's from the government release, but in Hong Kong, there is no routine release in about this information. So we work with the lawmaker Charles Mork to submit question in the legislative council from 2013. So for Hong Kong Transparency Report, our work is basically draft the questions with reference to the other government transparency report and the corporate transparency report. You can see there is a table there. That's our questions. We list what we want to know from the government and ask the government to reply. Fortunately, the Hong Kong government reply most of the information. And second is we send inquiry to the government departments. According to the Hong Kong's Code on Access to Information, is the Hong Kong version of Right of Information Law. So this is the basic two sources. And fortunately, there were lots of corporate companies report they received requests from the Hong Kong government. So so far there were 7 international companies. Unfortunately, no Hong Kong company reports such data so far. Oh, sorry. Yeah, we'll see Google, Microsoft, Twitter, Yahoo, Apple, Facebook, Verizon. So let's go to the data. Here we have the data from 2011 to 2015. So the first chart you will see is the user data request. It accounts for 92% of the Hong Kong government request to the service providers. You will see basically the request is from the Hong Kong police. And for the content removal request, it's basically from the Department of Health, because they ask the service providers to remove the illegal sales website. So overall, basically, police is the major requester. So let me see the trend. I think there's good things after 2013 that the Hong Kong government sent less requests, in particular to the 7 service providers which has published transparency reports so far. We know 2013 is the Edward Snowden leak, and why the Hong Kong government sent less requests? I have another finding. So we see that the service providers, the 7 service providers, Google, Facebook, Twitters, in general, they reject 40% of the user data requests from the Hong Kong government. So the Hong Kong government may be more cautious when they send requests. Yes, fortunately, Google released some anecdote about how it handled the request from Hong Kong government. If the government sent, for example, without court order, for example, if the information is incomplete, they reject. And there's another trend is that this data is from Facebook. We see that there is a significant rise in 2015 to the request to Facebook. One issue is because in the late 2014, there was the Occupy Central movement happened in Hong Kong. It's a mass protest asking for a genuine universal suffrage in Hong Kong. So after the protest, there was arrest. 16 people have been arrested for their speech calling for violence online. So yeah, the police send more requests to the social media platforms. And some issues. First, the government, we send requests, we send inquiry to the government to ask the data about how many requests is complied. how many requests is accepted by the service providers, but police force reject to review such information, and as well as the Inland Revenue Department before. So we don't know how, we don't know such data from the government. So as you see now, 40%, this data is from the service providers. And second, the police also reject to review how many requests were sent with court order. I think it's a basic issue. According to the law in Hong Kong, government bear no responsibility to send user data request with a court order. But we know a lot of international companies have a policy required that the government send with court order, but the local company that have no such a policy. So another issue is that there's a lot of guidelines inside the government departments about how to handle the request, how to send requests, how to review such information. That's another issue in the Hong Kong government. So improvement. We start to send such, we start to ask that information from the government in 2013. Fortunately, we have more and more information about that, and the government, I think the Hong Kong government did a good job. Most of the information we inquired, they respond properly. And we raised recommendations for the Hong Kong government. First, set up the independent review of government request practice. Second, establish and make public the internal guidelines. And third, make public the release of the information on the government request. We also recommend local service providers to release transparency reports, because it's not just about the government. I think in Hong Kong, Ji Wong and Ming Xuan are going to discuss the situation in Korea and Taiwan. Compared to these two jurisdictions, the issue in Hong Kong is that Hong Kong is not a democracy. So, and we have a comparatively weak civil society. So the public awareness is an important issue to exert pressure on the government in terms of the transparency and privacy protection and freedom of expression. So from last year, a lot of initiatives from the civil society start. For example, you see there is a rating project called Who Has Your Back, Who's on Your Side, rating the local companies, their performance over how they protect our privacy and how to protect our freedom of expression against the government. And there's two initiatives released this year. One is the Access My Info, help the citizens to obtain our information from the telecommunication companies. This is important because it raised our awareness about our privacy issues. And second is the Internet Freedom Manifesto. So yes, and in particular after the 2014 protest, the rising civil society exert more pressure on the Hong Kong government. Okay, thank you.
Yeah, hello, I'm Johnson, the project manager of Korea Internet Transparency Reporting, which is analyzing the status of South Korean government's internet censorship and surveillance. Transparency report on national level is of high importance because it informs the public about national level of internet freedom. And this is especially important in a country with an authoritarian system where the government's request of surveillance and or censorship has a de facto binding effect on the corporation, resulting in a long arm reach of the government power. So the companies hardly have room for discretion. First, I would like to introduce the current status of internet censorship and surveillance and its transparency in South Korea. In South Korea, a total population of about 50 million, about 100,000 online contents are taken down yearly by an administrative body, KCSC, Korean Communications Standard Commission. On the issue of internet surveillance, each year about 2,000 accounts were intercepted and the communication metadata of about 200,000 accounts and the subscriber identifying information of about 600,000 accounts was provided to the law enforcement agencies. The number of search and seizure on the communication service provider, which can acquire all kinds of communication data, is not disclosed, but we roughly estimate that over 3 million accounts were surveilled through the search and seizure, based on transparency report of 2 major domestic OSPs. This is for the internet only. If you include the figures of all sorts of communication, the numbers are going to be much larger. It's about 10 million accounts, almost 20% of total population. Because the scale of Korean government internet censorship and surveillance is so immense, acknowledging the citizens of such a seriousness through the transparency reporting on the national level is very necessary. In regard to the level of Korean government transparency, for the surveillance, the government discloses the total number of interception and the provision of communication metadata and subscriber identifying information, which is reported from the local service providers to the government twice a year. There is law which mandates the communication service provider to report to the Ministry of ICT about the status of data provided to the investigatory agency. But as I mentioned, the government does not disclose the status of the search and seizure, which can collect the whole spectrum of data, including the contents, metadata, and subscriber identifying information. For the censorship, KCSC discloses statistics on takedown requests of each portal by categories and general reasons, and publishes a white paper triennially with more detailed statistics. Also, they disclose more specific details upon FOIA requests, and deliberation committee held semi-weekly can be attended by anyone who applies in advance, and the minutes are uploaded regularly on the homepage. But we cannot know the entire contents of all individual information because they usually review just a few representative cases for each category or only the problematic part in one information. I do not believe the government would, by its own initiative, establish better practices in regard to the transparency. When I request the disclosure of more detailed statistics, they just answer they do not manage or store separately such statistical data. And they seem to reject the request on the ground that such disclosure can disturb investigatory activities. I think it will solve only the legislation which mandates government to disclose more data. And to raise awareness on the surveillance and censorship of the government and for proper evaluation thereof, the disclosure of merely the total number is not sufficient. A more specific and detailed statistics is needed. For surveillance, statistics for suspected crime, duration, scope of surveillance, and rate of indictment must be also disclosed to the public. Also, more individual cases should come under public scrutiny. In Korea, after the revelation of indiscriminate surveillance on popular messaging chat app cases, people started paying attention on a massive surveillance and transparency issue. And the company in Korea began publishing their transparency report. And recently, the campaign calling for citizens to inquire their mobile service provider whether they provided the users' information to investigatory agencies is being held. And it was discovered that numerous politicians and NGO activists and labor union activists and journalists were being surveilled. As a result of this revelation of individual cases, public became more aware of and alarmed by the government surveillance. In order to bring this individual case to light, notice to the affected user must be strictly given. I feel that the concept of transparency in relation to the communication surveillance and censorship seems to be moving from a unilateral disclosure of the total number by government or corporation to the right to know whether a person information has been given to the government. I think this is a positive development in achieving Transparency Report Project's ultimate goal. Yeah, and to find out more about the South Korean status, please visit our website. And thank you.
Okay, thank you for the representation from Hong Kong and Korea. And we think the issue is very important, not only about the transparency, but also freedom of speech and privacy issue. So now we'll come the Taiwan transparency report, Ming-Chun He.
Hi everyone, I'm Ming-Chun He, and I'm responsible for Taiwan Internet Transparency Report. And I'm working in Taiwan Association for Human Rights, briefly as TAR. So, Taiwan Internet Transparency Report is promoted by Taiwan Association for Human Rights, and what TAR did most in the past were focused on the traditional human rights issues like anti-death penalty, freedom of expression, right to housing, refugee, etc. But there's only one exception, at least an exception in Taiwan. TAR also cares about the personal data protection. The reason is also based on the context of national surveillance. And that is also the root for us to do Taiwan Internet Transparency Report. We published a report last year, so you could download the report from the link. And the TITR, or Taiwan Internet Transparency Report, is the first project of TAR mainly focused on the digital human rights and the public transparency. So in this report, the data we use mostly come from government. We try to use the data already released or the data we asked by Freedom of Government Information Law. And if above two ways were useless, then we'll ask the legislators for help. Also, we combine some corporate transparency report to finish this report. So in the past, Taiwan seldom burst a large-scale event on the surveillance or censorship. We only had one big event in recent years that happened in September 2013. And it is Taiwan's Supreme Prosecutor Office tried to wiretap our parliament president our whole parliament and report the result to our president. So just this big event. So yes, but I think event list doesn't mean that we are safe. Why? Because according to Taiwan Judicial Yuan's statistic, Taiwan's police and prosecutors department actually do over 15,000 communication surveillance every year. And this is a rather high density compared to Taiwan's population. If we compare to United States, you will find that although the number is already quite large, but this 2 billion population country just issue about 1,000 to 4,000 warrants every year. So, and the second reason why we are unsafe is because we also sent over 80 requests to government last year. And we also know that besides the communication surveillance, many other Taiwan's government departments also gain some power from different laws to force internet corporation hand over the personal data if it is necessary. So let's form this the law basis provided by different departments, and you could see that some departments they are very unfriendly. They just tell you go to visit their website and try to find your information yourself. They don't want to talk the specific laws. So in the first year, TITR took lots of effort to clarify this situation. We try to make government tell the citizen what the legal basis, the statistic, and the standard operation procedure are. So there's two parts. For personal data request, actually for both parts, personal data request and the content removal request, these two parts we got is so limited. You could see it's a little small, but you could see that the largest number is 2,237 for Criminal Investigation Bureau. And of course, it's incomplete if you include all communication surveillance mentioned before. You will get much and much higher. So, so in the first year report, we have a strong need to integrate other corporate and other public report to supplement our insufficiency. We try to integrate some corporate transparency report like Google, Yahoo, Facebook, Microsoft, Yahoo, and Apple, and to tell the citizen our government is very dishonest or at least very lazy. So that is, the data is really ridiculous if you compare to other corporations. Yeah, I think I don't have to mention too much. Yeah, you could just see. So for content removal, based on the statistics provided by the government organization, they say they sent 1,234 requests, and the successful rate is 91%. But if we check the Google's data, we'll find that the successful rate is just about between 0% to 30%. So there's a big gap of compliance rates provided by the government and corporations. And the other problem is we find that in Taiwan we have an organization, semi-official organization named iWin. And according to NCC, the iWin's outsourcing operation include administrative technical operation, monitoring internet activity, implementing the mechanism for online computer, but not related to the exercise of public power. So they just got a case and transferred to different government departments. And but if what we got in the last year, we found that some government departments are unclear about iWin's duty and responsibility. They take iWin as final arbitrator. So, and iWin never clearly introduced its own duty and responsibility on their website. So yeah, that's another problem. So both two parts, we got the information is so limited. So why information is so limited? We think the problem seems to happen on the interpretation of freedom of government information law, because some government departments try to tell us that the freedom of government information law could only force government to release the existing data. And if you by the law, citizens could not force government to make new statistical format. However, if we rethink that just a half year ago, Taiwan's government surprisingly topped the global open data index made by Open Knowledge Foundation. I found that is maybe the reason we think it's not true, because open data and freedom of information in Taiwan use the same law. And open data often organize and create new data format. I mean, government, of course, could make new statistical format. After all, every format should be created first, then it could be open. So open become impossible just when some sensitive issue were attached. And so let's talk about some suggestion and improvement. The first of this part is we lack an authority to responsible for right to privacy or internet, and it will make for deficiency. That is, we lack the overall policy, and it's hard to proactively investigate whether there is a privacy risk or not. And third one is it's easy for government to make some excuse to reject the data release. And the last one is the operational procedure to sending requests are different and applicable each by each government. For each government, it's different. And the second one, we suggest that we should increase the protection scope of communication surveillance, because the communication surveillance law in Taiwan only regulates the behaviors related to telecom. We will find that according to official document made by Ministry of Justice, once the email content has been stored, and then it will not be regulated by the communication surveillance. It will regulate by code of procedure, criminal procedure. And the communication surveillance law is a more stricter law compared to code of criminal procedure. And otherwise, we also have no successful appeal case now. Yeah, so because if you are under surveillance, under communication surveillance, then after the communication surveillance is finished, you will get a notify. And we found that there's 9 cases the citizens try to appeal. They are under improper communication surveillance, but no one is success. So the third one is, well, the local telecom and the internet corporation lacks transparency. And in Taiwan, still no local telecom and internet corporation try to make their first transparency report. And this is really important because the transparency report makes the corporation itself accountable, and the customer could know how their data or content be treated under corporation's policy. And if we have some corporate transparency report, it will also help this report, Taiwan Internet Transparency Report, to supervise whether government tell complete facts or not. So that's all. Thank you. Thank you.
Okay, thank you, Minxuan's detailed presentation. According to the statistics, it seems like Hong Kong and Korea is more honest than Taiwanese government. Okay, then welcome Mr. Clement Chen, who will introduce us the surveillance and censorship in China.
Thank you. And actually, by compared to the jurisdictions that were described by previous speakers, there are no initiatives of transparency report yet in China. But given the recent legislative developments concerning information rights, namely freedom of information and personal data protection, And given the changes in the regulatory approaches of surveillance and censorship on the part of the government, there is some possibility for the Chinese society to introduce transparency report on surveillance and censorship in China. So I'm going to give you a very brief description of the whole picture without going into the details. Oops. Oh, sorry. Yep. There are two legal bases for Chinese citizens to request information concerning surveillance and censorship. First of all, there is a quasi freedom of information regime in place in China since 2008. Unlike Hong Kong, which has a relatively soft code of access to information, China does introduce a statutory basis of the right of access to information. Although there are very broad exemptions, including but not limited to privacy, trade secrets, state secrets, there are also some special exemptions. For example, information disclosure shall not endanger social stability without any statutory definition of what amounts to social stability. But it is still remarkable that the Chinese legislature allows citizens to challenge government's non-disclosure of information before the court. So this is rather landmarking when we consider the ingrained history of secrecy in China. And according to my statistics, it seems that during the first several years of implementation of the FOI regime, China is doing quite well in terms of the volumes of information requests by compared to other relatively mature FOI regimes. And you see in the that the average FOI requests per 100,000 population, China is doing pretty good, even better than Canada and Germany and Switzerland. And in terms of the FOI litigation, you can see the line with the square indicates that there is a very steady increase of FOI litigation during the past 7 years, which indicates that the Chinese citizens are rather active in asserting their right to information. Okay, apart from the FOI regime, under some recent legislation concerning personal data protection, especially in the field of civil law, Chinese citizens are enjoying the right of access to their personal data held by internet service providers as well as telecommunications providers. Although in other areas, their access right may be rather limited. And even in terms of government held data under the FOI regime, citizens also are entitled to have access to certain categories of personal data held by the government, so which introduce the possibility of requesting for their personal data in terms of internet censorship and surveillance, made those requests with the government. But however, there is actually a huge imbalance between the privacy protection vis-a-vis government agencies with privacy protections vis-a-vis private sectors. Generally speaking, we can imagine that citizens may have broader right of access to their personal data held by ISPs, whereas they have very limited right of access to personal data held by internet regulatory agencies. And secondary, although in the old times it seems that we all know that the Chinese governments are having very intensive measures of internet surveillance and censorship. But it seems that in recent years, there is a change of the regulatory approach, which is the governments are increasingly open with the legal basis of surveillance and censorship. They are now literally making norms and other normative documents with legally binding forces, which indicates under which conditions your personal information is detained by ISPs and transfers to the government agencies. One typical example is the introduction of the real identity registration to almost every aspect of internet services, covering, in this chapter you can see that covering from the registry, your subscription to internet services, your subscription to telephone services, and microblogging, and instant messenger, as well as apps in smartphones. And in those regulatory, under those regulatory regimes, ISPs are under pretty stringent obligations of collect and preservations of real identity information of their users. Whereas it is very unclear to what degree are the government agencies under similar obligations of data protection. Also, from the part of censorship, there is some significant changes in terms of both the structure of governance as well as legal basis for censorship. Since 2013, the Chinese government formed a new department who is exclusively responsible for the so-called regulating internet contents. So it is empowered with extensive authorities in terms ranging from content removals to punishment of those internet users who have published the so-called harmful information online. Also, the Ministry of Public Security also publicly declare that they are now introducing the so-called Internet Policy Patrol on a daily basis. And the statistics shows that just in 4 months of last year, the online police has found more than 758,000 pieces of harmful information that violates the law, and have finished investigation of 70,000 cases, which means that in those cases, netizens will got punished. And you can see from the official website of the Cyberspace Administration, there are extensive and a great number of regulatory documents which regulates the internet content in relation to almost every aspect of internet services, and they are also publishing the administrative punishment decisions regarding content removals and other activities that are considered as in contravention of internet governance, internet regulations. So actually there have been some cases of in which citizens have filed FOI requests regarding the activities of censorship as well as surveillance in China. Although all these cases failed, and actually the information requesters were eventually detained on other grounds, it indicates at least that there are some very mature but yet fundamental channels of access to information regarding internet censorship and surveillance as well. So actually there are some minimum legal channels in place, but there is still a long way to go for the civil society to being able to really have access to those information and engage in further activism in terms of influencing the internet governance inside China. So that's a very brief presentation, and I look forward to your comments and questions. Thank you very much.
For the 4 presentators, distinguished presentation, and we are very sorry that we only most focus on the Northeast Asia, because now the fact is that it's only Hong Kong, Taiwan, and South Korea only have the government transparency report. So we are welcome that other countries can join our work. So now we are open to the floor and see if anyone have the question to our presenters. And the panel is will be closed on 1 o'clock. So we have 10 minutes.
Hi, I'm Paul Wilson from APNIC and the MSG. Thanks very much for these contributions. It's been a very interesting workshop. My question is about the Manila principles for intermediary liability. I didn't hear any reference to those. Maybe I missed something, but the Manila principles seem to be very useful in describing how, from the point of view of the intermediary, the companies that are actually carrying the data, how they should be able to deal with requests and so on, and what their expectations should be of transparency and so on. So I'm just wondering whether the Manila principles are being considered as a useful input into this process, or whether we're actually all well aware of them. Thanks.
Hello. Hi. Thank you for the presentation. A question on the data that was collected. I was wondering if there is a gender breakdowns on, especially on those that are that are under surveillance. What are the percentage of male and females? And also, if you have any information on the types of contents that were blocked, that would be good to share, because in Malaysia we don't have those data as well. Thank you.
Okay, I want to know about the process of blockage for internal content and external content. Thanks.
Hi. I wanted some more clarity on how the 3 or 4 of you use the right information laws to get this kind of data. What were the things you were looking for in relation to the internet, and how did you go about it? What is the criteria?
Okay, so maybe who wants to answer the question first? We have 1, 2, 4 questions. One is about gender, and it's about the law about the freedom of information. And you mentioned about the principle, about principle. So.
Hello. Let me respond to the access to information law question first, because I think the issue in Hong Kong is a little bit, I would not say terrible, but it's not so good as other advanced economy, because there is no access to information law in Hong Kong so far. As I mentioned just now, we send the inquiry to the government departments according to the Code on Access to Information. It's not a law, it's just a code. It was made in 1995 when Hong Kong was still the British colony under the governance of Chris Patten, in response to some call from the democratic, the democracy parties, which is the anti-China party. So Hong Kong has such a code to handle the access to information. But after that, a lot of people, scholars, civil societies, calling for to make it into a real law, but the Hong Kong government continue to reject, including Hong Kong Transparency is calling for to make the access to information law, because even though let me introduce the situation in Hong Kong law. Even it's a call on access to information. We can't allow us to send inquiry to the government, and the government bear the responsibility to respond. So far, the Hong Kong government did a quite good job. Even every citizen just send an email to any department, to the officer in charge, they will respond. But some departments better than other departments. So that's why I said we are lack of a guidelines, a very detailed guidelines about how the office to handle such requests. But the most important thing is that we need to have the law to make it a mandate. Thank you.
Well, since China does not have a transparency report, I would like to only reply to the question of intermediary library. There is some a special clause in China's tort liability law, which distinguish two kinds of liability, which is strict liability and fault liability. Generally, it states that if ISPs are aware of its users is using internet to disseminate information in violation of other people's rights, then the ISP has an obligation to notify relevant agencies and to take down the content in the first place. But it is quite controversial as to what amounts to aware of, and that's the very delicate line of between strict liability and fault liability. So far, I think ISPs are willing to risk, not to risk, and just take down any information as well as soon as they got notified about suspicious violations of law by those information.
Okay, for the first question about Manila principles, first, it's a little embarrassing, but Taiwan, in the past, we seldom participate the international principles, and it's some kind related to our political background, but yeah, but I think it's, I'm not sure, because Manila principle is about like principle about content, right? Internet content. And don't have a good answer, sorry. But it's hard for in Taiwan to use international principle, even though it is an official one, and the Manila principle is an unofficial one, I think. So yes, so it has some difficulties here, and for the second question about content which blocked, which type of content be blocked or mechanism. In Taiwan, last year report we investigate mostly about we focus on iWin, this organization, and because iWin will get all requests from civil society, And so we put large effort in this area, in this organization, and try to make clear what's the standard they transfer each case to different government. For example, which content you will be categorized as pornography, or which content will be categorized as I don't know, cyberbullying, yeah, such as that. But the fact is what we get is really limited. Yeah, I win. I don't know why. Really don't know why. I will never clearly talk about that. They have some statistic on their website talk about how many cases they receive and how many cases they have done. They've done means they already transfer to each government, but they don't talk too much about this transfer, the standard of how they transfer. So yeah, sorry, I not very know, but it's one of our main goals to try to achieve next year. Okay, so maybe I just, okay.
Yeah, Kenny Huang, Executive Council member of APrIGF. Basically, I just make a phone call to IWIN a few days ago because I need to prepare another section. That's what happened in the day after tomorrow. But anyway, I try to figure out what sort of process they're doing for the notice and takedown. But eventually, I just realized how they operate because I was not aware about this organization. And they just told me they have a procedure and they have an industry practice how to handle that kind of request by anybody. Anybody can just do a request, say I need to take down some website they are considered cyberbullied or consider pornography. And so they will review the request and resubmit the request to relative government organization or government authority, and or even request the issue to the service provider. So service provider can take action after that. And my next question to them is, how can you enforce that kind of action to be happen? And they say if that obviously violated the law, they need to follow. I say, are you a judge? How can you review that considered violated law? So they couldn't answer the question. And eventually they tell me they are multi-stakeholder model. I tell them I'm from APrIGF. APrIGF is a truly multi-stakeholder model. We have 6,000 members, I think. So all our behavior based on the best practice, based on the best interest of our member. And what's your membership? And he said, we have some member. And how can you select the member? He cannot mention how the member was selected. So they just consider themselves as a multi-stakeholder model, but they didn't realize how to perform a proper multi-stakeholder model in practice. So basically, we have the talk tomorrow talking about how to incubate a multi-stakeholder model in practice. So that's what I know from IWIN point of view. So let's answer your question. They don't have any legal basis. Basically, they perform the notice, but they don't take. They cannot enforce to take down, and they're just doing their best effort to take it down, and through their political muscle from different government agencies. So that's what they did, and quite unfortunately, it's not very civilized.
Okay, just follow up. And in fact, IWIN last year we tried to, yeah, I think IWIN should publish this procedure on their website because that is what they should do it. And even And last year we asked IWIN, and in fact, IWIN's responsibility is just for the young guys. They are founded or they are established by the law which is related to the young guys. So they are just responsible for the content which is improper for young guys. But in fact, they receive all kinds of content now, all kinds of requests now, and they say we have to do that because citizens just send their request to us, and we cannot refuse or reject the request. I mean, I try to tell them, you of course could reject those requests because it's not your responsibility to handle these cases. And if in Taiwan we don't have any organization or authority to handle these cases, that is the problem of our government. That's not the problem of you. So, yeah. So that's just a follow up. Yeah.
Does anyone want to add some conclusion or no? Okay. So, do you have more questions? One. Okay, because we have to close soon. So yeah, pretty short.
I mentioned the Manila principles because I think they're quite relevant here. They're about the liability of intermediaries for the content that they carry. They set down the principles under which takedown orders should be given, the predictability and the reasonable sort of common law or natural law approach to these things. It's not an international treaty, it's a voluntary code which came out of the Manila RightsCon meeting last year. It's available online in multiple languages on manilaprinciples.org. They've been seeking signatories, individuals and organisations to come on and actually give support to those principles. So I do, for anyone who's not aware of them, I do sort of recommend having a look at the Manila Principles. It's a very good model, which is actually in the interests of internet users, of civil society, and also the technical organisations that are providing the services, because it actually makes transparency the sort of number one sort of principle behind all of these intermediary issues. So I just thought I'd mention that in case it's not well known. Thanks.
Okay, thank you for
actually, just more information on that. There is a session on Manila Principles tomorrow. At what time is it?
What time is it?
4 p.m.
4 p.m. in which room?
I forgot the room, but
okay, we will join that. Okay, thank you for the suggestion and the questions. I think it's a very good discussion, and we think maybe we should put more international principle. I remember that EFF, they also have another guideline about the government surveillance on the online rights. So yeah, and also the gender perspective, I think is also important when we request the information from the government. Maybe we should ask them to provide the statistics about the gender. Yeah, so okay, thank you for everyone, and now it's time for lunch. The lunch is on the second floor. Okay, thank you.